Coming to this now, a recent Labour court case involving an employee who reported sick only to go to a rugby match has set a new precedent on sick leave. The Labour court found against the employee after the company had appealed a CCMA ruling which found against it. So to find out what this means to workers in general, we're now joined by Labour law expert Abigail Butcher. Abigail, thanks for your time and good morning to you. I think let's bring into context what exactly we're talking about here. An incident that involves an employee who actually took sick leave, but was found to have travelled at least an hour to Port Elizabeth, actually, for a rugby game.
Good morning, and thank you for having me. Yes, so general context. So obviously we understand that all employers are entitled to sick leave. But the corresponding legislative framework there is that employers are entitled to request proof of incapacity, which obviously relates to medical certificates.
Right.
So we see the Basic Conditions of Employment Act come into play there. But I think what was really interesting about the Woolworths case and how it pointed workers to, as you say, the do's and don'ts in relation to sick leave, is that at its core, in relation to any leave, I mean, we could make the example for sick, for family responsibility, that dishonesty or honesty and the way in which that affects the employment relationship. So whether that creates a trust breakdown in the employment relationship is really the question that the Labour Appeal Court honed in on. So we saw at the CCMA level that the employee in question was reinstated with back pay. And the CCMA took an interesting approach in that they took an over-technical approach, one would argue, to the manner in which the employee was charged. So the employee was charged with gross misconduct and breach of company policy in relation to sick leave. And the evidence that the arbitrator said was not necessarily in relation to dishonesty, and he could not find that the trust relationship had broken down. So we'll recall that under labour law, in order for dismissal to be substantively fair, evidence must be led in relation to the trust relationship between a company and the employee.
Yeah.
And the Labour Court tended to agree. So I'm not dealing with the issue of procedural fairness because it was eventually abandoned by the courts. But the Labour Court tended to agree. It said, well, look, the employee said that he had recovered from his illness. So he had a medical certificate. He recovered from his illness. And that's the reason that he then attended the rugby match. So, I know you said there was the 20-minute there. They made the parallel to say, well, 20 minutes to drive to work or an hour to drive to the rugby match. But nonetheless, his evidence was that he'd recovered.
Right.
And I think the Labour Appeal Court, one of the really key lines or one of the key takeaways from the judgment was this lenient approach to dishonesty cannot be countenanced. So the Labour Appeal Court really focused on the fact that the employee had been dishonest in the production of his medical certificate, which said that he was unfit to work for the entire duration of the day. And so that's the context that we find ourselves in. It's really a question of honesty in relation to leave,
right,
and the way in which employees are taking leave affecting that trust relationship between the company and the employee.
And I want to just touch on the trust relationship that you speak about, Abigail, because I think you've mentioned it twice or three times already. It's important to also note that this particular employee was in a senior position. It almost set a very negative precedence to his or her subordinates. So it's important to factor in that trust relationship between the employer and the employee. But we all know that this probably is something so common in many organizations, where employees can take leave and say they were sick, but knowing that they're going to do other personal engagements. What's the lesson here, especially if an employee may think at the back of their mind, listen, I don't have any previous warnings, so therefore I can get away with something like this and just produce a doctor's certificate?
So I think there's a couple takeaways. So from employee perspective, and interesting, the Labour Appeal Court, even though the warnings against that employee in question had lapsed, took into account warnings in relation to coming to work late, even in dealing with the issue. So I think the first takeaway there is the warnings don't necessarily need to be in relation to abuse of sick leave, in relation to abuse of company policy, any other leave, so generally not dealing with responsibility in the manner in which the company has said that one must in terms of its policies and its procedures and your contract. So I think that's the first thing is don't assume that lack of any other warnings are going to create a get out of jail free card here.
Yeah.
And I think the second way is to be really aware of your company's sick leave policy. So I think what's quite common in a lot of sick leave policies is there's an actual explicit provision which says that the employee is not expected to be performing any kind of activity, recreational activity, any other work for remuneration during the period of sick leave. So you're in direct breach of company policy there.
All right.
And I think the last thing that employees must just keep in mind is that the production of medical certificates is actually regulated under the Health Professions Act. So it's not necessarily even something that's regulated under labour law. There's a government notice issued under the auspices of the Health Professionals Act, which lists a set of requirements of what constitutes a valid medical certificate.
Right.
And in the absence of those requirements being met, employers are entitled to contact doctors, for example, to authenticate the veracity of those certificates.
Yeah.
And we understand, obviously, there's a privacy element to that, and there are issues of informed consent there. But to the extent that a condition is not disclosed, that's in order. But what can be authenticated is the extent to which the employee is actually fit to perform duty.
Right, Abigail, because I have to let you go in a few seconds, please allow me to jump in there as well. I have to get this piece from you. The message that this ruling also sends to the commissioners of the CCMA, what is it?
To be cautious in taking an overly technical approach to charges. And to the way that evidence is led in relation to the breakdown of the trust relationship. So CCMA commissioners should ideally or arguably adopt a common sense approach or a more holistic approach to evidence on the breakdown of the trust relationship. And in the absence of evidence being explicitly led with regards to dishonesty, if it's clear from the evidence that dishonesty is present, that a common sense approach to the trust relationship can be adopted to make a holistic finding. That's not to suggest that they should be swayed in any which way, but just that holistically the evidence should be considered.
All right, we'll leave it then. I appreciate your time this morning. Abigail Butcher from Clive Decker Hofmeyr, thank you so much for joining us and discussing this matter with us this morning.